This is a preliminary examination date for Kenneth Holmesley. This is for domestic violence third. I have a concern that I must address. I called a case, Mr. Riley, where you were supposed to be present on, and I was told you were downstairs. This matter was scheduled for 8:30, and due to a board meeting at the state bar, it was pushed to 1:30. Why is it at 2 o'clock? The court should have to wait while you talk to your client.
I certainly apologize, Your Honor. I have received some information from our prosecutor that I wanted to relate to my client at that time.
Why are you all waiting until 2 o'clock to relay information on a matter that was scheduled for 8:30 this morning?
Thank you, Your Honor. The information that I relayed was that the complaining witness was present here today, which I didn't know until we got here.
Okay, that was the expectation. It's scheduled for an exam. The expectation is that a complaining witness is going to show up. We should be proceeding with that expectation anyways, no?
Yes.
So why did that require you not be here?
In addition to that, there was discussion of the possibility of plea agreement that I wanted to discuss with my client.
Okay, well, we had a probable cause conference. What do you think those are for? That's exactly what they're for. How are we proceeding today?
It's my understanding that Mr. Holmesley now wants to accept a plea offer of a plea to domestic violence second with a sentencing agreement to no further upfront jail. In addition, the people would dismiss a pending matter that before Judge Ward, and I will get that case number whenever the court's ready.
I'm ready.
25-03678-SM, and we would dismiss that upon successful plea and sentencing.
Mr. Holmesley, that's accurate. You want to plead guilty to domestic violence second in this matter?
Yes.
You can't shake your head and make that face and say yes. No, because that means you're not ready to make a plea. If you need more time, then you just ask for that. You ready? Okay. And the plea agreement is that you'll dismiss a matter that's pending before Judge Ward.
That's correct.
Okay, and is there any other terms of
No
this?
further upfront jail at the time of sentencing.
No further upfront jail at the time of sentencing. That's a killable agreement. That's between you and the prosecutor. I'm the one who sentenced you though, so that's not my agreement. You understand that? I may decide that you're gonna do upfront jail. If I were, I'd give you the opportunity to withdraw your plea, okay?
So I have an opportunity to give it to the judge.
If at the time of sentencing, I decide that I'm going to sentence you to serve jail time, I will give you then the opportunity to withdraw your plea. Okay, you understand that? Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. Okay, you understand in this right that you have the right to proceed all the way to trial and you have the right to jury trial. Okay, you understand you're presumed innocent until proven guilty. And you understand that the prosecution has not proven you guilty, so you're going to waive your right to the presumption of innocence, and then you're going to plead guilty to a domestic violence second? Okay, and so you understand that comes up with waiving your right to trial, waiving your right to be able to cross-examine any witness called to testify against you, your right to subpoena witnesses that will testify on your behalf, your right to present evidence to any defenses to domestic violence, and then your right to remain silent and not have it used against you. You understand that? Is there anyone coercing you to plead guilty? Any promises? I'm sorry? You got to speak up, sir.
No.
Anyone coercing you to plead guilty?
No.
Any promises in exchange for a guilty plea? You can tell me what it is. What is the promise? No, tell me what it is. I need to know.
I just want to get this matter behind me.
That's not what I asked you, and I don't take pleas for people to get matters behind them.
Oh,
Nobody promised you anything? Anybody threaten you to get you to plead guilty?
No.
Okay, and you believe you're guilty?
No, ma'am.
I'm not taking a plea. You can call your witness.
Thank you, Your Honor. We're actually going to amend this to a domestic violence second, and it requested this matter be set for trial.
Well, we have a witness here. It's a final pretrial now.
That's fine.
We're not setting it for another one.
That's
They're
fine.
all here now.
Okay.
We can set it for trial. We can do May 26th at 8 a.m. May 26th, 8 o'clock in the morning for trial. You've been reluctant to plea the entire time anyways. It was evident in your facial expressions and your body language. But once you told me that you do not believe you're guilty, I am not able to take a plea anymore.
I'm sorry, I didn't.
It's not about apologizing. I'm not able to take a plea because you can't plea if you're not guilty. You have to be guilty to plea. You understand that?
I understand.
Okay, so we'll continue this matter to trial. And you're they're amending this from a felony to a misdemeanor. Are you requesting a bond motion today?
Your Honor, certainly since clearly this has been modified to a misdemeanor case, Mr. Holmesley has been in custody for some time. 14th of February. I think a jail sentence is unlikely, even if he were to be found guilty of that misdemeanor. So my request certainly would be for modification of personal requirements is released at this time.
Is the prosecution going to respond?
Yes, Your Honor. First, I'm not able to see what Mr. Holmesley's bond currently is.
$7,500 cash surety.
Thank you, Your Honor. This offense was committed while he was on bond for the case that's before Judge Ward with the same victim. He does have an extensive history. I do believe that this is an appropriate bond currently, given the threat to the community and the victim that the defendant currently presents.
Okay, and what is this bond in the case before Judge Ward? Was it revoked because of this? Looks like it's 1,000 cash surety. Is there GPS stay there? Even center?
It said it was.
Yes.
I believe there was.
Okay. And he has a Plea 53 set on that.
I don't think he has it set, but there is a violation form in this file. I don't know if it ever got set on the docket in front of Judge Ward.
Thank you. This again has been reduced from a felony to a misdemeanor. And so holding him on a $7,500 bond would be unreasonable. I will amend the bond to a 1,000 cash surety with GPS tagging. All other bond conditions, including the no contact order, will continue. Any additional matters for the record?
Now for the people.
No, Your Honor.